Hi, I'm Donna Wright, Communications Manager of the VIP Institute for Procurement, and I'd like to welcome you and thank you for joining us for the VIP webinar, Understanding VA's and SBA's New Service-Disabled Veteran-Owned Small Business Rules. The webinar was developed with the goal to help veteran businesses accelerate your growth in the federal marketplace. And that is what VIP is all about, accelerating the success of veteran-owned small business government contractors, and it's working. On average, companies have grown 64% 1 year after graduation from the VIP GROW program. VIP offers 3 different curriculums to give veteran-owned small businesses the tools they need to win government contracts. Programs are held in Washington, D.C. area, just 11 miles from the White House. Participants receive hands-on market-based instructions that help establish best business practices for federal government contracting, and the program is offered at no cost. VIP offers 3 different programs: VIP GROW, VIP START, and VIP International, all of which can be found on our website under nationalvip.org. This webinar series is made possible thanks to the support of SBA. Its goal is to provide resources to 20 veteran business outreach centers located throughout the country that support veteran-owned government contracts with entrepreneurial development services such as business training, counseling, and mentoring. And there's a resource they are a resource for VIP alumni to ensure their continued success in the federal marketplace. The slides and audios from this webinar will be made available on VIP website at nationalvip.org. It's now my pleasure to introduce a leader in his field, John Williams, partner with Polaro Mazda. John Williams has over 15 years of experience advising contractors on a wide range of government contracting matters and FAR compliance, including the federal procurement programs for small businesses. For example, 8A, HubZone, WOSB, and Service-Disabled Veteran-Owned Small Programs. He represents contractors in bid protest, size protest, and appeals, and related administrative and court proceedings. John's bio can also be found on our website. And without further ado, I will go ahead and have John begin presenting.
Donna, thank you so much, and good afternoon, everybody. It's great to be with you. Thanks for joining us for the webinar today. As Donna mentioned, I'm with Polaro Mazda. You can see a little bit about our firm here. We represent contractors, and many of our clients are in the various federal procurement programs for small businesses, including the SDVOSB program. So it's a program that's really near and dear to our hearts at Polaro Mazda, and it's a program that's undergoing some changes, and that's why we're here today to talk about the new rules. So to give you a little bit of an overview of where we're going, we're going to talk about the SBA's and the VA's new rules on ownership and control of SDVOSBs. I'll try to give you an overview of what those new rules look like. And what should you do in response to the new rules? What action items do you need to take away from this webinar? There have also been some new rules regarding protests and verification appeals, so we'll talk a little bit about that. And then I'm going to end the webinar with a mention of a couple of recent SDVOSB cases, not necessarily about these new rules, but just cases on SDVOSB issues that I think you all should be mindful of. Feel free to use the chat box to submit questions during the webinar. I'm going to try to end a few minutes early so I can answer some selected questions during the webinar. But any of the questions that I don't get to, we'll be following up with you by email afterwards. So please don't be shy about submitting questions. And as Donna noted, the slides will be available for download afterwards. So everybody that wants the slides will be more than happy to download them. All right. So let's get rolling. Let's give you a little bit of a background on why do we have these rule changes. So I think most of you probably know that there are 2 SDVOSB programs. One through the VA that applies to VA procurements, and the other is through the SBA that applies to all other federal agencies. And they have their own rules. So the VA has their set of rules, the SBA has their own set of regulations. And that's been confusing. I think that's one of the biggest challenges that SDVOSBs have is navigating these two programs. And the SBA and the VA, in many respects, they're very similar, but they're not entirely the same. And they sometimes would come to different conclusions on the same issue. So that can make it a little bit challenging to navigate. And on top of that, the VA verifies firms. So if you're going to do work for the VA as a VOSB or an SDVOSB, you have to have verification from the VA's Center for Verification and Evaluation, or CVE. So that's a process you have to go through up front to be certified, whereas the SBA doesn't currently verify firms. If you're eligible according to SBA rules, you make that determination and you self-certify your status in SAM. Now, I did emphasize here that SBA currently doesn't verify SDVOSB status. There are some rumblings, some rumors, some of you may have heard that the CVE verification process may go government-wide. So right now, you only need CVE verification if you're working on VA projects, but that may go government-wide, so it may be necessary for SDVOSBs and on all federal agency projects. That's not imminent, but I think we might be heading in that direction. At least that's some of the rumors, so just file that away. If you don't work for VA and you're not CVE verified, that's okay right now, but that might change. So the standards for veteran ownership and control under the prior rules have differed a little bit. And I think generally speaking, the VA's rules have been a little more flexible in the past. The SBA's rules under case law really do not permit, that this is historically, I'm talking about the prior rules, did not permit non-veterans to have any control over the SDVOSB. There are some cases from the SBA's Office of Hearings and Appeals where the judges have said, the SBA rules require veterans to control all decisions, and all means all. So you can't have a non-veteran with control over any decision. So that's how SBA has previously approached control for SDVOSBs. The VA has been a little more flexible. They have, in the past, they have permitted non-veterans to have control over some very limited issues. Their rules have permitted rights of first refusal when selling ownership. At least in prior years, they had permitted some veto rights over amendment provisions, but pretty limited, but nevertheless, I think a little more flexible than SBA has been historically. So that's the background. And because of I think largely the confusion I mentioned, Congress stepped in last year and tried to resolve some of this confusion by creating one unified set of rules for SDVOSBs. So we want to, the idea is we want to move away from having two different sets of rules run by two different agencies for SDVOSBs. We want to have one sheet of music. So the 2017 National Defense Authorization Act, that's really what started this one sheet of music. And that law gave sole authority to the SBA for determining ownership and control of VOSBs and SDVOSBs. And this 2017 NDAA also gave the SBA's Office of Hearings and Appeals, which I'm going to often call OHA. That's what we call it around the office, the Office of Hearings and Appeals, or OHA. So that SBA office already, they have the ability to hear appeals from CVE protests and verification determinations according to the 2017 NDAA. So when Congress passes a law, it doesn't immediately start impacting the agencies. The agencies have to implement regulations that will incorporate the law into how they do business. So once Congress passed the 2017 NDAA, this past January, SBA and the VA each proposed rules to implement the law. And so those rules, they go through a public notice and comment process. So the public was given an opportunity to comment on the rules, and then the rules get finalized, and they just went final on October 1st. So that's the reason for this webinar. You know, just a few weeks ago, both the VA and the SBA new rules went into effect on October 1st. So they are live and in effect right now today as I speak. So the SBA's rules, and because, remember I said Congress wanted there to be one sheet of music, and they gave that authority to SBA. So as of now, you know, as of October 1st, SBA's rules exclusively govern ownership and control requirements for all VOSBs and SDVOSBs. So that means whether you're at the VA going through a CVE verification or you're self-certifying in SAM for an IRS procurement, either way, you have to be eligible under the SBA's regulations. So that's one of the big changes, that we're for ownership and control issues, we now, regardless of where you are, VA or any other agency, we're looking to SBA rules. Because what the VA did in their rules that have been changed as of October 1st, they basically say, go look at SBA's rules. They say C13 CFR, that's where the SBA's rules are. So now the VA's CVE is still responsible for verifying VOSBs and SDVOSBs for VA procurement. So I don't want there to be any confusion about that. You still have to go to CVE and be verified if you want to do SDVOSB or VOSB work for the VA. That process has not changed. VA is still doing the verifications. I mentioned before that VA might eventually, the CVE might eventually do verifications for all federal agencies for SDVOSB status across the government. But right now, CVE is continuing to do verifications that apply for VA procurements. So if you want to work with the VA as an SDVOSB, you've got to go to CVE still. The change is that if you went there today, CVE would verify you using SBA's rules. That's the big difference. The VA would no longer use their own rules for ownership and control because their own rules say, go look at SBA's rules. So that's what we're really focused on now, are SBA's rules. And I mentioned self-certification still applies outside the VA. So if you're not working for the VA, you don't need to go to CVE. That has not changed. You self-certify in SAM. It might change down the road. I think there's a decent chance of that. So, you know, if you're on the fence about whether to go for CVE or not, it might make sense to go ahead and get in CVE. And you know, you're an early adopter, and especially if you're going to work with VA, you have to be in CVE. But if you're not working for VA, you can still self-certify. So what's in the new SBA's rules? I'm going to drill down on them, but just a quick summary of what's in the new SBA's rules. So they now permit the surviving spouse to maintain SDVOSB status in certain conditions. That in the past, that was one of the confusing differences between the two programs. The VA's program allowed the surviving spouse to do that. The SBA's program didn't. But now it's in the SBA's rules, which is good. SBA will now permit 5 unanimity requirements for non-veterans, but there's only 5. So what I mean by a unanimity requirement, I'm going to give you more details on it, but what I mean is a requirement that all of the owners have to agree on these decisions. You have to have unanimous consent. There can't be anyone saying, I don't agree with that. So if your company only has one owner, this isn't relevant to you because you're always going to agree with yourself, I hope. But if you have minority owners, that's where this comes in. So you're the majority owner, you're the veteran. If you have a minority owner, that minority owner, it can't have veto rights. There can't be unanimous consent requirements. You have to be in control of all decisions, except now there are 5 that SBA has specifically put in their rules that you can have these unanimity requirements. And I'll tell you what they are in just a slide or two. And then SBA also added several situations that create what they call rebuttable presumptions of control by a non-veteran. But unfortunately, they really didn't give us clear guidance on how to rebut the presumptions. So I'm going to drill down on that too as we move along. This is just a summary. And I see we got a question, what happened to the 51% ownership rule? That has not changed. So the rules still require that the veteran or service disabled veteran has to own at least 51% of the business. No change there. And perfect segue, because the next slide, SBA's rules on unconditional ownership. So at least 51% of the business has to be unconditionally and directly owned by one or more service disabled veterans, or of course in the case of a VOSB, veterans. So SBA's rules were revised a little bit to be similar to the old VA rules, and they indicate that unconditional ownership means that you can't have these conditions on the ownership. That in other words, the veteran doesn't fully own her shares. There are conditions on the shares, that she's only allowed to have the shares if these conditions are satisfied, or she can't do all of the things that you would ordinarily expect a veteran can do with her shares because she's subject to some conditions that the other owners have placed on her through the operating agreement or the bylaws. You can't have conditions. It has to be unconditional ownership, free and clear. I totally own my 51% or more. I can do whatever I want with it. I have all the voting rights you would expect of being a 51% owner, etc. But the rules do recognize that there are exceptions for death or incapacity. So you can build into the agreement, your operating agreement or your bylaws. If you have business partners, you can build into the agreement that what will happen to the veteran's ownership when the veteran dies or is incapacitated. So there used to be some issues in the past with doing that because, again, that was considered to be the all means all approach I mentioned. Veteran has to control all decisions, including even when the veteran passes away, that there shouldn't be a condition on what happens to the veteran's ownership at that point. But now the SBA's rules at least recognize that you can plan ahead for that in your operating document. And again, just to avoid confusion, this only comes into play if you have more than one owner. If you're the sole owner of your business, you shouldn't have any conditions on your ownership because you're the only owner of the company. I have a question here about rights of first refusal, so what a right of first refusal means, and again, if you have more than one owner, this is what comes up when you want to sell your ownership interest. And it is very common for the operating agreement or the bylaws to say, before an owner can sell her shares, she has to offer a right of first refusal to the company or the other owners to buy out the stock. So if I'm an owner, I can't go sell my shares to Donna without offering my other business partners and the company the right to buy my stock first. At the VA, that's been okay. There was a court case a few years ago that said under VA rules, it's permissible to have a right of first refusal. But SBA has not allowed a right of first refusal. They view that as a condition on the veteran's ownership. The veteran shouldn't have to give a right of first refusal to the company. The veteran should be able to sell her stock to whoever she wants. So under these new rules, which look a little bit more like the VA's rules used to look, I would like to say we can do rights of first refusal now, but we're not certain about that. So I think this is, to get what we get a little bit later on, but what do we do now? What should we be doing in light of the new rules? One action item would be if you have a right of first refusal in your operating agreement or your bylaws, I think it's worth at least considering how that is set up, and do we have any heartburn over that in light of these new rules. SBA's rules now also say they will not take community property laws into account when assessing the veteran's ownership. So, it used to be if you lived in a community property state, like I think California is one, that you needed to do something called a transmutation agreement to make, if you're married, to make clear that your spouse does not have an interest in your ownership in the business. It's outside of the marital, assets, essentially, which frankly just led to some crazy results when the people were trying to get into the, get SDVOSB verified. And fortunately, SBA saying we don't need to worry about that. They're not going to, treat your spouse as a co-owner of the business just because you live in a state that uses community property laws. Pledging ownership as collateral. This is something that will come up for you if you're going to go try to get a bank loan, possibly, or bring on an investor in the business, that they might expect you to put up your ownership interest as collateral for the loan or the line of credit or what have you. And so the good news is that SBA's rules, I think this is a business-friendly provision. It indicates that you can use your ownership as collateral. That is not going to affect the status of the ownership as being unconditional. I mean, it is a condition on your ownership in some sense because you pledged it to the bank, but the SBA understands you may have to do that to get a loan. So that's okay. However, you have to make sure that the pledge of your ownership follows quote unquote normal commercial practices, and that you still have control absent violation of the terms. So what are normal commercial practices? Well, that's not defined. I can tell you that if we're talking about a traditional bank, you went in for traditional bank financing, that's going to be considered normal commercial practices because the bank, they're giving loans all the time. They're a traditional bank. Where it becomes potentially a little more dicey is when you're getting a loan from a private party, because private parties maybe aren't ordinarily giving out loans. It might be, close family member, it might be, a business partner. So we have to be more careful about loans there. And I think under these new SBA rules, if you have a loan or you're thinking about getting financing that is not from a traditional lender like a bank or a factoring company or someone who's in the business of providing financing, if it's a private party, you need to be careful about the terms. I mean, that was always the case. It's not like that necessarily is brand new as of October 1st, but I think the way they've tweaked these rules a little bit, they now have a little more flexibility to say, we're concerned that loan makes you too dependent on the non-veteran that allows the non-veteran to control you. So I think we've got to be especially careful now post October 1st if you have a loan from a private party or you're thinking about getting one. Financial benefits of ownership. So the SBA regulations, the veteran's got to be 51% unconditional owner. And as part of that, you need to have the financial benefits commensurate with your ownership. So what that means is, if you're the 51% owner, you should be getting 51% of the profits. And the rules specifically say that. So you can't institute some type of profit redistribution where the other owners end up getting more profit than they should, and you're not getting at least 51% of the profit if you're the 51% owner. You also have to receive 100% of the value of each of the shares of stock that you own if the stock is sold. So, this raises a question sometimes about bonus plans and what they call phantom equity plans, like ways that you can try to compensate key employees. There is a question of whether, how SBA would view those arrangements under these rules, and based on some of the comments that SBA made when they implemented these rules, I still think that those types of plans are okay, but I think it really, generally speaking, but it depends on the specifics of the plan. So here's another action item. If you have, or if you're thinking about implementing some type of a bonus plan that might be tied to profits, or what they call a phantom stock plan or something along those lines, I think it's worthwhile to spend a little bit of time looking at the specifics of that plan to make sure that we feel good it's going to be okay under the SBA's rules. I mentioned before the rules now permit the surviving spouse to maintain the eligibility of the SDVOSB after the service-disabled veteran passes away. This slide here gives you the particulars, how that would work, when it would apply, and then for how long you'd be able to continue it, essentially. And this is exactly how it's worked at the VA before. So if you're at all familiar with how it worked at the VA, it's going to be the same with SBA. So I've been talking about ownership, and I'm of the last several slides, and I mentioned that SBA, it's now their sheet of music for ownership and control. So those are really the two key eligibility requirements for VOSB and SDVOSB status. We've got to be owned and controlled by veterans. So the veteran has to be in control, and what the SBA rules now say is that the veteran has to be in control of management and daily business operations. And they put in a definition in the rules of what are daily business operations. And you can see it here on the slide. So, I mean, I think at a minimum, when you're thinking about how you're operating, and also what do your documents say, you want to go back and take a look at them, and also, stop and think about your operations to make sure that you can say that you, as the veteran, are in control of at least these things that are considered to be daily business operations. It's not an exhaustive list, so it's not like you can just stop here, but at least these are the types of things that SBA considers to be daily business operations that the veteran has to be in control of. And the veteran also has to be in control of long-term decision-making, except for extraordinary circumstances. And I'm going to talk about that in a moment. So let's put a pin in extraordinary circumstances. But generally speaking, the veteran has to be in control. I mean, this gets back to the all means all. It's not quite all means all anymore, but it's, there are very limited exceptions even under the new rules. SBA did make a little tweak. I don't know how many of you are set up as partnerships, probably not too many. Most of our clients go the LLC route, which I think is advisable in most cases. But if you are a partnership, they have tweaked the rules so that the veteran must control 51% of the aggregate voting interest, but the veteran is not required to be both a general and a limited partner, which is something that was in the prior rules, and they thought they were being a little more flexible in changing that now. So rights for non-veterans. What can you do if you don't have any business partners? You can disregard this and just think about what this would mean for you if you decide to bring on a business partner down the road. And maybe this helps you, frankly. I think part of the problem for SDVOSBs are that, and other small businesses, is that the rules are so limiting in the rights that the minority owners can have, that can make it difficult to bring in investors. Because the investors will often, the typical investor would say, well, I'm giving you money, I want some rights. I want some of those unanimity requirements that I was talking about before. I want some veto rights. I want to make sure that you're running this thing well if I'm going to put my cash into it. But you just can't do that in these programs. And especially when it was all means all, prior to October 1st. So at least I think the SBA has moved a little bit in the direction of recognizing maybe a little more business-friendly approach to this, and that SDVOSBs, in order for them to grow, in many cases, they're going to need to bring on minority owners. They're going to need to bring on investors. It's not just going to be the sole owner, single member LLC in many cases. So they're starting to show a little more flexibility there, just a little. But I think that's a step in the right direction. And so on this slide, I've just kind of given you the general principles initially, and what we mean by the term supermajority is that if there's a supermajority voting requirement is a requirement where you're specifying it's not just 51%. 51% is a majority. So a supermajority means to take this action, there's got to be more than just a majority. And you can decide what the supermajority is. You can say it's 60% or 75% or whatever it is, but it's something greater than 51%. If you're going to institute supermajority voting requirements, you have to tell CVE if you are verified by CVE, because they're going to want to know that that a veteran can still control even with the supermajority requirements. Because often the supermajority requirement, the reason you have it is so to give the minority owners a little bit of control, maybe a veto, essentially a veto right. Because if I'm the 51% owner and Donna owns 49%, and the operating agreement says we can't sign a new contract without 75% of the owners agreeing, that's a supermajority voting requirement, because I can't do that on my own. I only own 51%. To take that decision, I'm going to have to get Donna to agree to it. And that means Donna has a veto right. She can just say, no, I'm not good with that. And then I can't do it. And that would be a problem if I was the veteran and it was a day-to-day operational decision. But there are these extraordinary circumstances that SBA rules now say, well, you can make that a supermajority. You can give Donna a veto right, as long as it's only these 5 decisions, which they truly are extraordinary circumstances. Adding a new owner, dissolving the company, selling the company, merging, or declaring bankruptcy. And I just want to be really clear. If it is not these 5 things, you can't make it a unanimity requirement or a supermajority requirement or a veto right, whatever you want to call it. These are the only 5 decisions that you can give your minority owners or owner a veto right over. The veteran has to control all other decisions. So that's why I say they've shown a little bit of flexibility, not a lot, but at least I think this is, and you may, if you currently have an operating agreement with you have minority owners and you control everything, you do not have to go give your minority owners the rights to veto these 5 issues. You can if you want to. You're not required to, though. So I want to be clear on that. You don't have to rush and go out and revise your operating agreement to give your minority owners these rights, but you can. And what I think you could also think about as an action item is, if I'm going to be bringing on an investor down the road, would it help me make that investor more attracted to my business if I was able to give that person these 5 rights? I think it would help. I mean, it may not be as many rights as the investor would want, depending on how much they're investing, but it's better than nothing. It's better than saying, just give me the money and then you're totally along for the ride. At least they can give you, the investor, these rights. So that's how I would view these. And maybe with your current partners, maybe you have a conversation. I mean, maybe you've made a commitment to giving them some rights when you're able to, and now you're able to give them these 5 rights. And I think that's very fair and equitable if you have a business partner, that these major decisions that they would have a say-so on. So that's something you have to decide amongst first yourself, and then if you have partners, how you want to handle that. So the other big area where the SBA has put in rules for control is that they put in a bunch of circumstances where they might find that the veteran doesn't control. So these are like, I guess a bunch of warnings, watch out for these situations. If you have this situation, then we being SBA, might say that the veteran doesn't control. We might say the non-veteran controls. And if the non-veteran controls, you got a problem. If you're you're trying to get verified or you got protested, we have to be able to show the veteran controls except in those extraordinary circumstances that I just finished talking about. So what are these circumstances that they've now put into the rules? So here's a list here. So non-veteran is involved in the management or ownership and is a current or former employer of the veteran. If you've got that situation, they might look at it and think, we believe maybe that non-veteran controls. Or if you have a non-veteran that receives the highest compensation, or if your business is co-located with another firm and there's some common ownership between the two businesses. If you're sharing employees or resources, equipment, services with another firm in the same or similar line of business, and there's some common ownership, that could also be an issue. If there's a non-veteran that has equity in the SDVOSB and is also providing critical financial or bonding support to the SDVOSB, depending on the type of work that you do, there might be a critical license you need, like a contractor's license, and if a non-veteran has this critical license, that's another circumstance where SBA may find that the veteran doesn't control. Or if there's a business relationship with a non-veteran that affects the veteran's ability to exercise independent business judgment. I mean, basically all of these situations kind of roll up to this general point or concern that the veteran, sure, that person might be the 51% owner and the veteran might control all the right decisions on paper, but in practice, we're concerned that the situation looks like a non-veteran has too much influence, that the veteran might be dependent maybe for the financial support or all the contracts that they're receiving or the critical license that the veteran doesn't have but the non-veteran has. I mean, that's SBA's thinking behind these rules, is that we can look at your paper, we can look at your operating agreement, your bylaws, your stock certificates, so we can get a sense if you've set it up correctly on paper. That really should be the easy part. The harder part for them is assessing whether you're eligible in practice. Are you operating in a way that's consistent with what you're saying on paper and it's consistent with the requirements? I think that's the problem that SBA perceives they're trying to solve here through these rules by saying, look, if these circumstances exist, we may find that the veteran does not control. So, I mean, the action item, you've got to look at yourself, your operations. Do you have any of these situations, anything that's arguably close to any of these situations? And I've got a few more to run through here coming up on the next slide. So a non-veteran provides a loan to the veteran or the SDVOSB. Now, a loan or a guarantee in and of itself isn't enough as long as the loan is on commercially reasonable terms. It's another phrase I'm putting in air quotes here. If you could see me, that I mentioned before, normal commercial practices. Now we've got commercially reasonable terms, not very well defined. Again, if we're talking about like a traditional bank loan, that's going to be normal commercial practices or commercially reasonable terms. If you're getting a loan from a private party, it could still be commercially reasonable terms if you set the loan up in a typical way, and it doesn't give the non-veteran the ability to control. If they're just providing money, that in and of itself wouldn't give the non-veteran control. But the SBA's new rule says they will look at other factors. Okay, there's air quotes again. And we don't know what those other factors are. So you might have a loan that's on normal commercially reasonable terms, but there are other factors out there which we don't exactly know what they would be, but they concern SBA. So maybe the closeness of the other dependents on the non-veteran besides the loan. Or on the earlier slide, we talked about ownership interest. If the non-veterans provided a loan and they own part of your company. So, the action item is if you have loans from a non-veteran, like I mentioned before, and it's not a traditional bank financing, we should think about, is that financing set up in a way that we're going to be okay under the new rules. Another one here, that if the veteran doesn't work for the SDVOSB during what are the normal business hours for the industry. I really don't like this new rule. It's, because I've worked with a lot of clients that, they work all the time around the clock. I do it too. I was at my kid's school earlier today, and I'll probably work after quote unquote normal business hours this evening to catch up. And I'm sure a lot of you folks do that too. But if you're in an industry that, the typical business hours would be considered 9 to 5, and you work nights and weekends, what's SBA going to say about that? I mean, under the new rules, sounds like they could say, maybe we don't think the veteran controls if he's not there 9 to 5. He's not working during, he may be working, but he's not working during normal business hours. So I really don't like that rule at all, and I suspect you guys don't like it either. Last one here, also really don't like this one. That if the veteran does not live within a reasonable commute to the business's headquarters or job sites, they can conclude that the veteran doesn't control. And they say this applies regardless of your industry. And they also said that the fact that you answer emails and communicate through the phone is not enough, but they don't say what is enough. So, because in the past we used to say, look, businesses might have offices in different states, and we don't expect the veteran to be on a plane every 5 days to be in each office. The veteran can make sure the other offices and job sites are running well through email and conference calls and WebEx, etc. You don't need to physically be there in with today's technology to stay in control. But SBA, I don't know, maybe they got tired of hearing us say that, because they specifically put into the rules that's not enough without saying what is enough. So, action item here, if you just have one office, you're good. This isn't going to be your requirement unless you live very far away from your office. What is a reasonable commute to your office? But if you have multiple job sites around the country, we probably need to have a conversation about what are you doing to maintain control. And emails, that may not be enough. It doesn't sound like it will be. So everything I just talked about, the last few, those are concerning, especially the last couple. But these are all rebuttable presumptions. I said that before, but I didn't emphasize it. I wanted to wait till this slide. So on all those circumstances I just mentioned, SBA may presume the veteran doesn't control, but you can rebut that. So you're not automatically nailed. You get an opportunity to tell them, no, don't draw that conclusion. Here are the reasons why the veteran is in control, even though I don't work during 9 to 5 hours. So you can rebut the presumption, say I work 50 hours a week, but I do it during these times because of my child care obligations or because of whatever it is. You can rebut the presumption. It's just that the rules don't really tell you exactly how SBA, what is SBA going to accept? What do they think is a reasonable rebuttal? And what are they going to say, no, that's not good enough? We're just not going to really know that until we start living with these rules. So I think if you're in any of these situations and we need to, you potentially need to look at rebutting the presumptions, at this point, we're trying to come up with the reasonable position. And that's something that I'd be happy to chat through with anybody. If you're concerned you're in one of these situations and you don't know if you'd be able to rebut the presumption, so we're just at the point now where we're putting our heads together on what's a reasonable position, because we don't have a lot to go on from SBA in terms of what they will or will not accept. So what should you do based on the new rules? I've been talking about this all along, so I won't spend as much time reiterating the points I've already made, but these action items, if any of these circumstances apply to you, you should really be thinking about, what do we need to do to rebut the presumption, or do we need to change the, look at the right of first refusal in our operating agreement and consider taking it out, or so it really, I think a lot of it starts with reviewing your operating agreement or your bylaws. And that was one of the questions I saw come up. Yes, as of October 1st, you really want to make sure that your operating agreement or your bylaws are consistent with SBA's regulations. That's whose rules govern now. It's SBA for ownership and control of SDVOSB issues. So all the things we've talked about, community property, surviving spouse, ownership, control, all those issues, we're only looking at SBA's rules, which is what I've been talking to you about today. So you want to make sure your operations and your operating documents are consistent with what we're talking about today, which are in SBA's rules. If you have a minority or non-veteran partner, you could, like I mentioned before, you could consider giving them the 5 veto rights, but you can't give them any more, so don't be overly generous. There's only those 5. You don't have to, though, so I want to underscore that too. You're not required to give them those rights, but you can. And I will also, I think your operating agreement or your bylaws in most cases should be okay, because if you're already CVE verified, the rules haven't really changed all that much. If you've never been verified before, it's important to look at the operating agreement. If you've been verified by CVE, there are a few exceptions like the right of first refusal issue, but you probably won't have a whole lot to do in your operating agreement. It might be more important to assess your operations. How are you actually operating? How far are you from the office? What hours are you working during? Do you have any non-veterans that have significant control? Those are the things I think that for many of you, that's where you'll want to focus. It's important to look at the operating agreement too, but my guess is that the current operations will be more critical to assess for the bulk of you. So the VA's rules, like I mentioned, they now just point to the SBA's rules. They did, in terms of ownership and control, they did make a helpful change to their regulations for joint ventures. They had just had something wrong in the past about profits for joint ventures, and they fixed that, which is good. So as of October 1st, the profit rule for joint ventures at VA is fixed, which is great. CVE protests and appeals. So VA, there are also new rules for this. Like I said before, you still go to CVE for your verification if you're going to work at VA. That has not changed. You got to go to CVE and get verified or get re-verified. But if you get a bad decision from CVE and you want to appeal, you used to appeal to the VA. Now your appeal is going to go to SBA's Office of Hearings and Appeals. It's going to go to OHA. So that's the big change there, that we get to go outside the VA for an appeal and those are administrative law judges at OHA. So you would get to appeal CVE to an administrative law judge at SBA. You have to do that within 10 business days after the adverse decision from CVE. And you also, now if you want to file a protest on a VA contract against SDVOSB or VOSB status, you're going to file it with the contracting officer. That's always how you file status protests. If you want to challenge an SDVOSB, you send your protest to the contracting officer, and you have to do that within 5 business days after you learn the identity of the successful offeror. But unlike the past, that protest is going to go to OHA, which is really strange. So in the past, the VA would have decided the SDVOSB protest. But now the contracting officer is going to send the protest to the SBA Office of Hearings and Appeals, which I think is really strange that we're going to have protests decided by the administrative law judges. Usually the judges have only ever heard appeals from protest decisions. Now they're actually going to decide the protest. That's only for protests on VA contracts for SDVOSB or VOSB status. I see a question. I guess I moved too quickly past the profit point. So the rule change for joint venture profit, let me just go back to this. So the old rule required the SDVOSB partner in the joint venture to receive at least 51% of the JV's profits. But the SBA's rules say the profit has to be shared commensurate with the work done by each company. The SDVOSB may not do 51% of the work in a joint venture. So if the SDVOSB does 40% of the work, which is the minimum, then they would get 40% of the profit. They get their profit commensurate with the work they perform. That's what SBA's rule has said, and the VA just revised their rule to line up with SBA's rule. All right, so just last two slides here, and then I'll have a couple minutes for additional questions. Just want to tell you guys about a couple of recent SDVOSB cases that are interesting. There was the Federal Circuit just recently decided this PDS Consultants case, which dealt with the Vets First program, the VA's SDVOSB program. We call it Vets First. That's the law that created that program. And the Kingdomware case dealt with Vets First. So this ruling was about a potential conflict between the Vets First program and the Ability One program, and which one trumps. And the Federal Circuit concluded that when the two programs are in conflict, the Vets First program trumps over Ability One. So this is just like Kingdomware. This is another ruling from a significant federal court. This is a U.S. Court of Appeals for the Federal Circuit, so right below the Supreme Court, that the Vets First program at VA takes precedence. So this is a good ruling for the Vets First program. The other case is a less good ruling for the Vets First program. The Court of Federal Claims in Electromed back in September looked at, there was a protest of a sole source modification for the VA's prime vendor contracts for medical supplies, which is a massive, multi-billion-dollar procurement, and the VA did a sole source modification. Several SDVOSBs filed challenges saying, that among other arguments, they said this is contrary to Vets First. And the judge actually agreed with the SDVOSBs and said it was contrary to Vets First. What the VA did was improper. However, the court determined that there was more harm to the VA if they issued an injunction because they really needed the medical supplies. And the court was concerned about issuing a ruling, even though they found the VA messed it up and didn't follow Vets First. The court was concerned about the impact that would have on getting medical supplies to veterans. I think the court also just felt like they made some comments about the process that Vets First requires and the rule of two that is concerning a little bit. So it's unfortunate that the court agreed with the SDVOSBs here, but didn't ultimately issue a ruling that helps them. So still court battles out there related to Kingdomware and Vets First. I just want to keep you guys up to speed on that. That's the end of my slides. So I'm going to scroll up through the questions here. I see one, if a JV itself verified through CVE, then does the profit distribution apply within the JV, or does the verified SDVOSB JV stand alone as its own entity? So if I'm following the question, the SDVOSB JV is its own separate entity, but it's not going to do any work because it's what's called unpopulated. The joint venture doesn't have its own employees. So the joint venture entity gets verified by CVE, but all the work is going to be done by the member companies. And those member companies are going to make profit on their share of the work. That's basically how that works. So yeah, let me see if I can scroll up here to some other questions here. Yeah, so somebody asked, what about contributing? This is, I think, back to the question of working during normal business hours. And what about contributing a limited number of hours to a nonprofit company in addition to the regular? That should not be an issue at all. I mean, if you're devoting substantial time during normal business hours to the SDVOSB and you're doing a little bit of time on the side, even if it's during normal business hours for a nonprofit, I cannot believe SBA is going to have an issue with that. I think you have a very reasonable explanation there. Where it might get more challenging is if you really were using up all of the normal working hours on something that wasn't related to the SDVOSB. We have to maybe look at that one a little bit more closely. Couple questions around kids and the surviving spouse. I'm not aware of any provisions in the surviving spouse requirements that provide a similar benefit to surviving children. As far as I understand it, it's limited to the surviving spouse. And that doesn't mean that the children couldn't also work in the business, but there wouldn't be the same, sort of automatic carryover of the SDVOSB status, at least not that I'm aware of. I haven't seen anything indicating they extend that to surviving children. Somebody said, I thought that it was approved October 1st that the CVE process will go to SBA. No, and this is something, I'll just say it again to clarify, and I hope I didn't confuse it before. So as of October 1st, CVE is using SBA rules, but the CVE verification process is still with the VA. So it's still a little bit strange that we have the VA using another agency's rules to do its verification. Okay. Yep. Yeah, look, everybody's saying no sound anymore. Maybe you just want to email everybody and tell them, sorry, we lost connection with 2 minutes left.
Yeah. think we're back. I think we're back.
All right, sorry about that. Well, it looks like we might have lost connection there for a couple of minutes, and we've reached 4 o'clock. So there will be an audio, I understand, of the webinar. So I assume even though you guys weren't hearing me, it was probably recorded. So you'll be able to download here maybe the last couple of questions that may not have gone through for you when we lost connection. Sorry about that. And we will follow up with all the questions that didn't get answered today to make sure that if you submitted a question, you get an answer. So thanks again, everybody, for participating. Really appreciate it. Hope this was helpful. Enjoy the rest of your day.
Thank you, John, for your excellent presentation on understanding VA's and SBA's new S-Service Disabled Veteran-Owned Small Business Rules. Thank you, everyone, for your participation. All PowerPoint slides, John's bio, and also the webinar recording will be uploaded to the nationalvip.org website. You can look for it under resources under our webinar library. Again, we hope you found this information presented to be helpful. You'll also be receiving a 3-question survey. We really appreciate your feedback here at VIP. So please take a moment to fill your survey out. Thank you. Have a wonderful day, and we wish you continued success in 2018.